Hey everyone, I'm Brian T. Bradley. I am an asset protection attorney. You may or may not have heard me talk and lecture on, wealth and how to protect your wealth and your assets on various podcasts and investment shows. And if you're an attorney, you might have heard me lecture on asset protection in the 21st century on various continuing legal education seminars like the National Academy of CLEs. I am the senior managing partner of Bradley Legal Corp. I am also of counsel attorney at Laudmill and Laudmill, the leading expert in advanced asset protection and strategic planning. And I'm also an advisory board member and lead attorney of the Asset Protection Council. But I want to spend time talking about trust and asset protection trust specifically, and really clearing up a lot of the confusion on what trusts even are, because it's like Baskin Robbins. There's a lot of different flavors and types of them. Not all trusts are the same. We have lots of different types of trust, and your typical family estate plan or revocable living trust is not an asset protection trust. They are not designed to be. They come into effect when you die, essentially to avoid probate, pass along assets, and for death taxes, your medical and financial directives. Asset protection trusts are what actually protect your assets when you're living from being sued from creditors while you're actually living. This is the third layer of protection. It's the dead of winter. Your, client is in the frozen tundra or Siberia of their life. They're facing a doomsday lawsuit. And this is the asset protection trust. It's the heart and soul of an asset protection plan. At this point, you or your client will have multiple assets, and a net worth is generally around 1.2 million of unprotected assets or more. And they possibly also have a high-risk profession like a doctor, a dentist, lawyer, CPA, entrepreneur, or real estate, full-time real estate investor, or turning that corner to become a full-time real estate investor. We call it the bridge trust since it's an easier concept to relate to. When you or your client is attacked by a lawsuit, we cross the bridge to the safety of the offshore Cook Islands and then break the bridge. But before we talk about the bridge trust, I want to talk about asset protection trust in general. And I want to start with just what is an asset protection trust. And I really want to spend time with this. And after this, you will know more than 90% of all attorneys out there about asset protection trust. An asset protection trust is what is called a self-settled spendthrift trust. So all self-settled means is that you are creating it for yourself, not for your kids or your grandkids. It's not Uncle Buck creating it for Orphan Annie. It is you creating it for yourself. So they are for you, by you, as your own beneficiary. And they have the very important spendthrift provisions in them. And you're probably somewhat familiar with another type of self-settled trust called a revocable living trust. Many of you have them, or your family members have them, your parents or aunts and uncles have them, grandparents. They are the same in that they are self-settled, created for you, by you. The difference is that with an asset protection version of this trust, it includes these critical provisions called spendthrift provisions. And what spendthrift provisions are is they are provisions that allow you to protect your assets from creditors. They are the actual teeth behind it. And for those to work, the trust has to not be revocable, but irrevocable. So it's a very different type of trust. Now, there are two major schools of thought, international and domestic. You can set them up here in the US, or you can set them up offshore in another jurisdiction or country. Now, I'm going to talk about them both and through a historical context. And it's very important if you're going to understand how the trust work and why the bridge trust works the way that it works, to understand the two base components. The international trust came first. It was created in 1984 in the famous Cook Islands. So that was like 36 years ago. So it has quite a bit of history and a lot of case law. I like and choose the Cook Islands if and when it's applicable, just because it offers the best home court advantage. Why it's the best home court advantage is because asset protection is what these trusts and the Cook Island statutes were specifically drafted for. They are the gold standard in the world, even today. And the greatness of the Cook Islands is that it starts with this statutory non-recognition of any other jurisdiction's court orders in the world, including the US. So I'm going to say that word again, statutory non-recognition, even in the United States. What this means is that if you have a judgment against you in the United States and they took that judgment down to the Cook Islands, your US judgment is worthless. It literally has no value whatsoever. Statutorily, the Cook Islands is prohibited from recognizing it. If someone wants to sue your trust in the Cook Islands, they would have to start their case all over from scratch. The person suing you would have to prove their case beyond a reasonable doubt. That's the murder standard, the highest legal standard in the world, the 99% sure standard. That is just incredibly difficult to meet. In the US, a civil case is just a 51% standard called a preponderance of the evidence. That's the, yeah, I think more likely than not, that's what happened. But beyond the reasonable doubt standard is just incredibly difficult to meet. You can't get a contingency fee attorney to represent you because they are not allowed down there. It's unethical in the Cook Islands, just like it used to be unethical here in the United States. But that got changed in the 60s because lawyers realized that if we can't get part of the action, it's hard to get lawsuits going. The claim, meaning the lawsuit, is not amendable, meaning that once you file your complaint, that's it. You can't change it or amend it after discovery like you can in the United States. It's common practice in the US to file a lawsuit, then get into the discoveries, start digging things up and amend your claim and go, oh, but, we found a different thing and we didn't even know about this. So now we're going to change our mind about what we're even suing you about and what we're suing you for. That's not allowed in the Cook Islands. You can't amend your claim. The person suing you will also have to front the entire court cost and flying a judge from New Zealand. And if you lose, you pay. And this is one of the single worst things that we don't have in the United States, that the loser does not need to pay the legal fees and costs of the winner. So if you get sued by somebody, for a completely bogus reason, just a complete frivolous lawsuit, and you spend $200,000 defending yourself in legal fees, and then finally the court throws that lawsuit out, you're still out $200,000. That person that sued you is not going to be given the bill because in our legal system in the United States, that would discourage lawsuits. And our legal system is run by trial lawyers who don't want, to discourage lawsuits. So we don't have that system. But the Cook Islands, they do have that system. And with a burden of proof beyond a reasonable doubt, whoever's attacking you almost certainly is going to lose. And so they'll be paying your legal fees also. So the disincentive is massive to sue you. Not to mention that the statute of limitations is short, and it's most likely already run since it's only 1 year. Basically, before they even take a shot at suing you in the Cook Islands and realize that a Cook Islands trust is involved, they miss their chance and they're going to be barred from even following a suit down there. In practicing law and even taking into account all of our affiliates and firms and lawyers, like hundreds of firms and attorneys, and dealing with thousands of these trusts, we've had a total sum of 0 plaintiffs that have ever followed any of our clients down to the Cook Islands. It's just too daunting of a task. It's not something anybody has ever been able to do successfully, and you would just have to pay a lot of upfront costs just to lose. Now, comparing this to the 4 things a client wants, remember that 4-part test: effectiveness, cost, control, and compliance. Effectiveness, the Foreign Asset Protection Trust gets 5 out of 5 stars. Statutory non-recognition, right? No other asset protection trust is this strong in the world. I don't know of a single person that would argue against that. A fully foreign offshore Cook Islands asset protection trust is just as strong as it comes. But what about the drawbacks? What about the other 3 tests: control, cost, and maintenance, compliance? On these, it actually falls short on. This is the fully foreign asset protection trust kryptonite. The cost will be high. It's expensive. The cost to just set up a purely foreign asset protection trust are about $35,000 to $75,000 range. And then it goes from $5,000 up to $10,000 annually to maintain. We tell clients to budget about $10,000 annually just to maintain a fully foreign asset protection trust. So setting up a fully foreign asset protection trust is not a small task. It's not a small undertaking. And if you are a purely foreign trust, you now have a lot more IRS reporting compliance and disclosures to file every year. You have to file the IRS forms 3520 and 3520As, which is a full balance sheet disclosure of all the trust assets and disclose all the trust roles. And even in some cases, even the entire trust agreement with the IRS. And that form is not cheap from a CPA standpoint. And it's not something most clients would be very excited about providing to the IRS. If the assets are moved offshore because like you have an offshore trust, which we would recommend if you're going to go through all this trouble of putting a fully offshore trust together, you probably need to then put the assets offshore as well. Then you have additional compliance called FATCA, account tax compliance. And of course, you're not going to be in control of that trust. It doesn't work if you're in control of it. For a fully foreign asset protection trust to work, you must be out of control and subject to a foreign trustee or a foreign trust company down in the Cook Islands. That's why they work so well. And so many clients are just not comfortable with that, and they're not familiar or comfortable with offshore banking. So the drawbacks, of a fully foreign asset protection trust, if we go back to that 4-part test, control. No, you're not going to be in control of that trust. Cost. They're not very reasonable. It's pretty expensive. And compliance and maintenance. You have a lot of compliance and maintenance fees and disclosures. So while we have the most effective trust in the world by far, it's not something that we usually start out with because of the fact that we have these 3 drawbacks, which brings us to the other option, the domestic trust. So let's talk about the domestic side of things now. The domestic US asset protection trust came around later after the offshore one, about 10 years later in 1998. So they're newer with less case law. The first state in the US to pass the domestic option was Alaska, of all places. The theory here was, we're sending all this money to the Cook Islands and other jurisdictions around the world. Why don't we just do it here? We've been doing it for years in Nevada and Wyoming for asset protection. Why not just create our own asset protection trust statutes? And so Alaska did. On a side note, we actually know the person who drafted that first statute, and he was a professor of my partner Doug at NYU. And then not to be left out now, over 19 US states have passed domestic self-settled spendthrift legislation one way or another, Delaware, Wyoming, Nevada, and others. And their motivation was, why do we want to send all this business to Alaska? We're already the states known for all of this. We want in on the action also. So the states are jumping on board, seeing that our legal system is now a threat and that things need to get done to protect your assets. And so asset protection in the United States, it's very valid, especially in these states and also federally. Lots of federal protection already exists through other plans like ERISA protection plans for exemption and other exempt asset classes. So asset protection as a concept is very important for you to understand is valid. How you do it is really where it gets important. The issue with the purely domestic asset protection trust is that the domestic asset protection trusts are really only created for the benefit of the residents of those states. And we now have problems of non-residents using other states' asset protection trusts, like California residents who don't recognize asset protection trusts and have no self-settled spendthrift legislation of their own, running off to Nevada and creating a Nevada asset protection trust, even though they're California residents. Well, the courts kind of stopped this in 2012 in California with a case called Kilker versus Steelman. Here they told a California resident they're no longer recognizing out-of-state asset protection trust, and this was upheld by the Court of Appeals. The advantages of the purely domestic asset protection trust were really popular in the early 2000s because a lot of people said, well, why go offshore? It's less expensive and it's easier domestically. So what were the advantages? Cost. The cost of the purely domestic asset protection trust is lower since it's not a foreign trust. A lot of domestic attorneys said that they were actually never comfortable offshore, but they felt very comfortable doing a Nevada trust where, I have a trust company who gave me a boilerplate language trust and told me how to do it. And then I went to a seminar and learned. So these trusts can be as little as $10,000 to set up. And the compliance is less since it's not a foreign trust. You have less mandatory IRS reporting requirements and disclosures, and you don't have the same compliance because they're not foreign trusts. Much of that compliance that we were talking about was related to a purely foreign asset protection trust. So Form 3520 and 3528 are not required. FATCA is not required because we have no foreign accounts. So that's the great, that's the good side. But what about the disadvantages? Well, on the negative side of the domestic trust, unfortunately, you lose on effectiveness of all things. We live in the United States of America. We have a constitution. First, the purely domestic trust has been around for half the time as the foreign protection trust, And we've seen rulings domestically taking down high-profile domestic asset protection trusts. Courts are just simply ignoring the choice of law clause. And courts are even ignoring them now in states that even recognize asset protection trust and have self-settled spendthrift legislation. The legal landscape's shifting again, and failure means breach and assets lost. And this is just unacceptable. And all you really had then was a false sense of security. They failed because of the foundation of asset protection. The foundation is not recognizing another jurisdiction's orders. Yet, like I mentioned before, the foundation of the US legal system is the US Constitution. The US Constitution, Article 4, Section 1, provides that every state must grant full faith and credit to the judicial proceedings of every other state. This means that, for example, Nevada can pass an asset protection statute, but it cannot ignore a California or Washington or Florida court order. So where the Cook Islands can just throw that California judgment in the trash, Nevada cannot. Nevada must respect it constitutionally and may even have to litigate it. So on this front, the purely domestic asset protection trust is very different from a foreign trust. Also, they fail on control. On the control front, they're weak since you must make sure to give up control of your domestic trust to a trustee for that trust to even carry any strength. And as I mentioned a few times, we're now seeing a pattern of case law that are weakening purely domestic asset protection trusts. We now have case law coming around, and they started coming around in 2006, 2007, 2009. And what we find is that these purely domestic asset protection trusts have failed. They have not been effective. The challenges are we have the full faith and credit clause, choice of law issues, meaning which law is the judge even going to apply? Just like I mentioned in other videos before, when you think that you're doing yourself a favor by having a Wyoming LLC hold a piece of, California real estate, and then find out that California law is going to apply anyways, the same thing is happening in the trust world. Then bankruptcy has addressed self-settled trust and established a 10-year look-back period. Even in those 19, domestic asset protection statute states, they created exceptions to what those trusts can even protect. And judges have just now found ways around them. So with recent trends and cases pointing towards all this new doctrine, along with the fraudulent transfer rule, all this is affecting asset protection planning, and even in states that recognize self-settled spendthrift trust. The modern transition of asset protection now is to transition away from older methods of asset protection towards more modern cutting-edge techniques, so that we can enable lawyers, and enable our clients to offer a broader spectrum of solutions to secure your assets from this out-of-control system. And though you had a lot of excitement in the early 2000s about the domestic asset protection trust, I don't think you have that much anymore. I don't know very many attorneys that still use the purely domestic asset protection trust. And if they do, generally, it's only used sparingly and for clients that live in the state and has that statute. Just like you wouldn't want to go and use a series LLC unless you're in a state that has a series LLC statute, the same is true for a domestic asset protection trust, and still only sparingly. And maybe it's just because there's a better solution that now exists. And so now I think we understand and see the land, we understand and see the landscaping, and the pros and cons from other videos of LLCs and both offshore and domestic asset protection trusts now, and what we're actually up against to protect your assets. So what do we do? It seems like a complete mess, right? But this is where we get to a better solution now. This is where we get to the hybrid options of trust. Just like hybrid cars, we get really good advantages when we take the good out of each of them. If you're our client, you have the benefit of the best of both worlds, called the bridge trust. It's the premier version of a foreign domestic hybrid trust. And my affiliate is, considered the creator of that hybrid trust over 28 years ago. The bridge trust is both a domestic and foreign trust. It's a hybrid. It combines the best of both. It's a foreign offshore Cook Islands asset protection trust. So it is actually a foreign trust drafted as a foreign asset protection trust. It's registered in an offshore jurisdiction in the Cook Islands from the day it's created. And then for the purposes of IRS compliance, it's bridged back into the United States. Its foundation is strongly planted domestically, also from the day it's created, to meet this two-part test under USC Section 7701. which is called the control test and the court test. And it lets us treat the trust as a domestic trust for tax purposes. So it's like having two passports. You can have a Swiss passport and the US passport. And as long as you have a US passport, the US will consider you as a US resident. And it doesn't care that you have a Swiss passport. The same thing is true with trust. As long as you meet this two-part test, the control test and the court test under 7701, the US says it's a domestic trust. So as long as you have a US jurisdiction that has primary supervision over that trust, we meet the court test. And as long as there's a US person with primary control over the trust, we meet the control test. So how do we do this? Well, we recite a US jurisdiction for the trust. Which one we will use depends on just where the client lives. If you live in one of those 19 states that have a domestic asset protection trust statute, then we'll use that state. If not, we're going to use Nevada, and it's simply because Nevada is the best. But we will just recite it, but not take all the effort to be a fully, registered Nevada domestic asset protection trust, because that's not the goal of the bridge trust. Remember, the bridge trust is a foreign asset protection trust. We are only using Nevada as a jurisdiction to meet that two-part test under 7701. What we want is to have the option to be offshore if and when we ever want and need that power. And then the flexibility of being classified as a domestic trust for IRS purposes. If we have no event of crisis, no event of duress, so pre-duress, pre-lawsuit, meaning before a lawsuit occurs, when everything is calm and happy, the trust is treated as a simple domestic grantor's trust. Just like a revocable living trust, it is literally disregarded for tax purposes. This means no IRS Form 3520 or 3520A, no IRS FACTA disclosures. Your assets can remain in your domestic US bank account. You have no need for an active foreign trustee. That foreign trustee is just going to be on standby. You remain as the trustee, and this gives you control, unless it's critical to give it away, like post-duress, once you do get sued, and your trust is tax neutral, and it's a tax neutral domestic trust, and your maintenance cost is lower. Now, post-duress, meaning lawsuit, now what happens? The trust protector, which would be your attorney or law firm, you would want it to be your attorney serving as a trust protector because you want the attorney-client privilege. So we would serve as your trust protector. We would declare an event of duress, which would cause a few things to happen. One, the offshore trustee that we said was on standby is no longer on standby. They become a co-trustee with you. And then two, they now have the power to remove you as the trustee because you're in the jurisdiction where the event of duress has occurred. And since you are there and you are vulnerable to the court, so we don't want you in control of the trust at that point. At that point, the offshore trustee can take whatever steps are appropriate to protect the assets of the trust. This then can include, opening up an account in Switzerland or Luxembourg, Uzbekistan, or other valid jurisdictions. It can include leveraging assets, stripping the equity, selling the assets. We're going to take whatever steps are appropriate based on the situation and based on the level of threat the lawsuit's providing. So the bridge trust is just incredibly effective and hits all the needs you're looking for. You remember that four-part test that we were talking about: ECCC, effectiveness, cost control, and compliance. Is it effective? Yes. It is a foreign asset protection trust. It is actually a Cook Islands trust. Two, control. Yes, you can be in control of the trust right up until the last second, where it's apparent that it's not in your best interest to be. Three, cost. It's much more reasonable. It's still going to be an investment on your part, but it's not going to be $50,000 and it's not going to be $10,000 a year to maintain. And maintenance and compliance, there is none. As long as we're not triggering the trust, there is no compliance whatsoever. If we have to trigger the trust and go to the full foreign asset protection trust, then you will have the compliance. But remember, at that point, you want it. You will be willing to pay for it because the benefit of the effectiveness is now the most important thing to you. So my recommendation here would be to email me for a consultation, and we'll do a full risk assessment and asset evaluation and see if the bridge trust is a right fit for you. My email is Brian, BRIAN, at btblegal.com. And my email is www.btblegal.com. And I hope that you have a better understanding about what asset protection trusts are and the different types of trusts that exist. And thank you for listening, and have a great day.